Good morning, everybody. This is Scott Jors, and this is another episode of the Wolf and the Neural Network. Today we're going to be covering Canadian privacy law, which is known as PIPEDA or PIPEDA. It's the Personal Information Protection and Electronics Document Act. Basically, it's federal privacy law in Canada. And we're going to talk about how this is applicable to the conversation and how this was made very reasonably applicable to Irving Shipbuilding and J.D. Irving due to their owning many marine installation structures, but then also the provisions that are listed directly under that act that describe a federal work undertaking or business. And I'm going to go quickly through the logic and show you why this is applicable. Because ultimately, the letter in response to this reasoning submitted to the Privacy Commissioner Employment Service Development Canada went missing from my mailbox. That's the letter that I speak about in episode 4 when I'm talking about EMIC and the military contracts and my GPS location set to that house. It fits in with that timeline and is an extremely suspicious event because Employment Service Development Canada told me they absolutely sent the message. Now, there are two pieces of legislation. There's privacy law, and it's the PIPEDA, but then there's the Canada Labour Code, okay? Now, inside of these two pieces of legislation, they have a definition that describes federal work, undertaking, or business. In PIPEDA, it just states means any work, undertaking, or business that is within the legislative authority of Parliament, it includes. Alright? And then Canada Labour Code states means any work, undertaking, or business that is within the legislative authority of Parliament, including, without restricting the generality of the foregoing. So they're identical, except the way that they're worded. And the way that it's worded with Canada Labour Code, it says, including without restricting the generality of the foregoing. Which means that the list that then follows, it can't restrict how general that is, right? It can't just restrict that it's a general applicability, right? Like it has to be a very specific instance. That's how I read this. And you'll note inside the document, we go through that and state that. And there are 10 definitions. Right? So it isn't just one that gets met. There are several that actually get met here. So what we're going to do is discuss the within the legislative authority of Parliament to state that is this work, business, or undertaking that Irving Shipbuilding is engaging in on behalf of the federal government considered within the legislative authority of Parliament. So here's the reasoning. So you look at Provision 91 of the Constitution Act, and you can go to Class of Subject 91.7. It's 7. Militia, military, and naval service and defense. These are specifically for those purposes, right? But it's also related to class of subject provision, navigation, provision 9110, navigation and shipping. Those are pretty reasonable, and those are within the legislative authority of Parliament, right? But then to take it even further, these ships aren't like airplanes or tanks. They are floating federal cities. They are considered core federal infrastructure. Public Safety Canada considers it critical infrastructure, and it's a federal economic initiative. It's incredibly interconnected and dependent on disciplines, trades, supporting staffs, and facilities. And it can't be mass-produced, such as planes, tanks, or basic ships, or as the Privacy Commissioner wanted to compare it to, fishing vessels. Simple, basic fishing vessels. And these specific ships defend the classes of subject that are within the authority of Parliament, and they are very clearly for the use of all provinces after they are completed, right? So here are the provisions to be more specific. A work, undertaking, or business that is operated or carried on for within connection to navigation and shipping, whether inland or maritime, including the operation of ships and transportation by ship anywhere in Canada. They are Canada's national shipbuilder with like one of the largest, if not the largest facilities in North America for building these ships. A work, undertaking, or business to which federal laws within the meaning of Section 2 of the Oceans Act apply under Section 20 of that Act, and any regulations made under paragraph 26. This one's more, you got to go into more of an argument, but this is where you bring in the argument for what are called marine installation or structures, MIS. And that is to say that, a regular fishing vessel, or say like a fisherman, since your ship is on the ocean and it has an anchor that can connect to the continental shelf, it is a marine installation structure. Your wharfs are marine installation structures. Each one of your lobster traps is a marine installation structure. Basically, anything that has the potential of interacting with the continental shelf is a marine installation structure. So barges, ships, traps, buoys, even just moorings that you put out in the ocean, right? If it comes in contact with that continental shelf, it's considered a marine installation structure, and so you are subject to these federal laws. And you can look in the Oceans Act and the Accord Act, and you can look at the workplace in the Accord Act that there are different things, that these are special regulations needed for places where people live and stay. Again, these are floating federal cities. They will stay in these for like 6 months at a time. You don't do that with an airplane or a tank, making these considerable instances of federal assets, something that needs to be considered as its own item. And why this is important is because J.D. Irving not only operates in Nova Scotia, so let's say they got an exemption from this and they only operate in Nova Scotia. Okay, well, J.D. Irving's parent company is in New Brunswick, so now they're sending information back and forth, but now they have different locations in Newfoundland, PEI, Vancouver, and Ottawa, and they share MIS between these, which means they're sending these marine installation structures between provinces, but also sending data back and forth between provinces, right? Making it more applicable. And again, they are the largest single building for constructing ships in North America. Okay, and here's what the OPC website states. All businesses that operate in Canada handle personal information that crosses provincial or national borders are subject to PIPEDA regardless of which province or territory they are based in. Again, they're sending back and forth between the provinces. Some might even go into the states. And then they're sending data back and forth. So there was the ships going back and forth, but then they're sending data back and forth here. And here's what I stated about to the OPC. States Irving Shipbuilding is registered in New Brunswick, but operating in Nova Scotia. Right? Again, what we just covered with all these different locations. When the OPC was asked about then, okay, if you don't consider Irving Shipbuilding, well then what about J.D. Irving? And laying these different points out, they would not answer in regards to J.D. Irving or the relationship or how PIPEDA was actually applicable. And they only mentioned Irving Shipbuilding, even though obviously the conversation includes the setup of the parent companies going down to that company and then the relationship between the provinces. Right? Now, the way that privacy law is typically interpreted, to my understanding, not privacy law, but law in general, is that when you read these definitions, you've got to read them the way that a normal person or typical average person would read them. If you go in and hide all this meaning in between them, there's no way for anybody to be able to reasonably understand it. So the way that it's written is the way that it's basically supposed to be understood. So now when I was speaking with the manager from the Privacy Commissioner of Canada, so this guy was a manager with the OPC, Privacy Commissioner, or the Office of the Privacy Commissioner of Canada, I had, instead of having him pull up PIPEDA, I had him pull up Canada Labour Code and read the definition for federal work undertaking or business. And when he read the points about shipping and navigating, he's like, oh, you might get them there, you might get them there. And then I said, this is in Canada Labour Code. And he's like, oh, well, this is PIPEDA. And I'm like, yeah, exactly. This is actually the same definition they used in your own code, but this one in Canada Labour Code states that it can't restrict the generality of the foregoing. Privacy law does not state that. Meaning that if you think it's applicable with Canada Labour Code, why is it? It should be absolutely applicable for PIPEDA, right? It makes sense. And here's basically what happened. After they tried to say that, oh, you know, it's not applicable, they said that, oh, now there's an order in council, or he said an executive order that omits it. So now it's gone from, no, it's not applicable, now you might get them on this. Now there's an executive order that omits privacy law. And I said, okay, well, you must mean an order in council. So what is the order number so I can verify this? Oh, well, it's a secret. So now this number is just some secret when Canadians should know at least that there is an exemption for the way the privacy law is being handled at Canada's national shipbuilder. So it doesn't even make sense. He couldn't provide me with a number. I did try to contact the orders, whoever's administering the orders in council. Nobody contacted me back. So I did try to resolve this, right? Showing you that it's very reasonable that privacy law is applicable. And the reason this is important is because I did a recorded meeting at J.D. Irving on January 27, 2020. And I asked for a copy of that recording because I absolutely dominated them and they won't provide it to me. Well, in addition to that recording, I requested access information about all my information, including all the letters that I was submitting and this process to see who was or was not seeing this or who had seen the recording at least, right? So tiers of information. Maybe they couldn't release the recording of the meeting, but release the information associated with who's seen what, which is applicable under privacy law, and you have the right to see that, right? Very reasonable request given we just did an investigation and I caught all these people lying. Even stating I would take a heavily redacted version as the preliminary version. And you can see why. Because once that gets out in the news or to the public that I dominated them that long ago, walked in there myself and walked all over them in a recorded meeting, what do you think's going to happen? That's right, a lot of Canada is going to back me and say, no, I absolutely did beat these people. And again, this is the very letter pertaining to the jurisprudence, because what happens is OPC and Privacy Commissioner of Canada and Employment Services Development Canada share resources in determining jurisprudence. So the applicability of these definitions. So I was talking to both parties. Employment Service Development Canada said that, no, we're not going to help you because it's outside of the dates. I said, okay, well, can you tell me what dates it's outside of? And they absolutely refused to, because the moment they accepted it, you'll see right in their provisions, they have to explain jurisprudence, which means they'd have to clarify these points. So again, I wanted this recording, and now this letter regarding this went missing, and that's a letter that's from September 15th, 2020, and you see the relationships with EMIC contract number 2, and then that property again, and now it seems I have physical mail going missing from my mailbox. These are really good questions, and it's completely within context. I did my homework on this. It does seem privacy law was applicable. I actually gave J.D. Irving over 6 months to implement that because I didn't want anybody exploiting that fact, including journalists such as David Pudgley, which all directly leads us into the conversation about David Fraser and how he's associated with this issue. Because I contacted him, I believe it was in August 2021, asking if he could explain PIPEDA and jurisprudence, and he replied very quickly stating he has a conflict of interest in this. So if you go back to about the 30th of July in 2020, him and Darren Lauer, David Fraser and Darren Lauer, make a video about privacy law and all this stuff. On the same date, you've got Kevin McCoy and CTV also doing a video from the shipyards. So now you can group all these people together just before I sent the letter to which McNeil would have resigned. So I sent my letter August 5th, 2020. McNeil then resigned on the 6th. All this happening within a week time span, and my letter was ready before they did those videos. So now you can see how David Fraser's now associated and carried through this issue. And the reason that's important is because I used David Fraser's work, I did a whole breakdown of his work to explain what I'd said in my reviews from the perspective of a top privacy lawyer in Canada. And that included where they should have done a privacy impact assessment, especially given the details submitted about Jim Perrin. And no reasonable person would have continued with an investigation given the information and data that I was submitting regarding these individuals. And that's why it's important. And then leads into the very specific technical issues and ethical issues with Jody Posabod, the third-party HR. They were a serious set of compromising issues, especially when combined. On their own, they were bad, but then combined as a setup, very bad. And that's how David Fraser is also reasonably involved in this. And that links back to a possible contract that they were given years before that, but it could also mean that they were hired in some capacity to consult on this issue and may not have been fully informed about the circumstances of what was occurring. Right, so that brings all these people together, and this ultimately links everybody right up to this date. But also kind of explains why the Privacy Commissioner Employment Service Development Canada would be lying, because they would reasonably have known about the issue with Mark Norman and the issue with the Privacy Commissioner and these individuals, because it had to do with the same time frame, which I never mentioned because I didn't know anything about. Showing how consistent this is and why the Privacy Commissioner Employment Service Development Canada would lie, but also why that letter might have gone missing from my mailbox. So this also explains why it took me till the end of March 2021 and what drug this out, because you can go back to February, right, where McCoy and McNeil leave office 6 months after, like I had stated, but now the end of March to get the final answer from Employment Service Development Canada to make it sure that they were not going to answer even basic questions. Then I engaged the Prime Minister on March 24th, 2021, and then I waited several months to have somebody contact me. Nobody did, and in fact, there was an instance of police stalking me to the store in that time frame. And it seemed like other events got strange, and that's when we caught those people taking pictures of us, etc. And it just seemed to get worse, so then I engaged that whole DL distribution list, including all those lawyers and all the media and all the political party, to which you'll see all the blips in my in the land views where it would normally be 0, correlating all that data and how we got to that point where I knew something bad was happening, and then you can see with the property blips confirming it. Well, given all these players, the issues with Mark Norman, DND, all this stuff with David Pudgley's around the same time, but also EMIC and these contracts, and these having to be signed off by his senior officials that are directly underneath him, and then all these issues with racism and them lying about it, mocking it, and then the Premier resigning, it's quite reasonable to state that the Prime Minister knew when Stephen McNeil resigned what the circumstances of that were, but at least the circumstances going back to the shipyard, because this involved his Defense Minister Harjit Sajjan as well, and all these people. So obviously he found out at some point. which all these definitions about the privacy law and how the government's interpreting them, they chose to try to say that these are no different than building simple fishing vessels. So now to associate J.D. Irving with these massive instances of marine installation structures where they're right on the Atlantic Ocean, they have these massive wharfs and stuff that they need to upgrade and everything. They're trying to compare them to a single small, say, lobster fisherman or a single small shipbuilder and say that's the same thing. Everybody knows it's absolutely not. But they would use them same laws to regulate fishermen and these smaller individuals because they have no form of recourse, and since nobody questioned it, there's nothing on record showing that they're giving preference to, say, a bigger company, possibly J.D. Irving or the other shipbuilders that are involved, without the proper orders and counsel. And we can go back and state who was responsible for that, but we'll cover that in another video. Okay, so anyways, that's privacy law. It's actually very straightforward, right? Like, it's just how you read the definition. Is that a reasonable way for somebody to interpret that? Yes. So you'll see why that's important, and you'll see why this now has to play in with the rest of the conversation. Anyways, thank you very much, and have a good day.